Welcome to the June 21, 2018 meeting of the Advisory Committee on the California Accredited Law School Rules, commonly known as the RAC, the Rules Advisory Committee. My name is Greg Brandis. I'm the Dean of St. Francis School of Law and Present Chair of the RAC. Let's go ahead and call the roll and establish our quorum. Dave, if you don't mind.
Barbary.
Here.
Brandis.
Here.
Gardena.
Here.
Goodman.
Here.
Hiramatsu. Lynn.
Here.
So that looks like 5 out of 6.
Correct.
That would establish our quorum requirement, so thank you very much. As with all of our meetings, we will offer opportunity for public comment. If time permits, I will also offer opportunity for public comment on particular items. But at this time, we welcome comment from the public on any matter, either a particular matter on the agenda or any matter you wish to bring before the Rules Advisory Committee. All right, seeing none, then let's move to the review and approval, as we hope, of our minutes. 2 sets of minutes were provided for this particular meeting. Our minutes from the March 22, 2018 meeting previously provided were edited upon motion at our prior meeting to remove some extraneous material. And so that is the primary edit made to this set of meeting minutes. And they've come back to us again. Now, as I recall, we actually approved them in our prior meeting, subject to that revision. So all I'm going to ask at this time is if anyone has any objections to the way the revision was conducted or any further comment, and otherwise we'll just deem these approved because they were approved at the prior meeting. Any objections or concerns to the way that was conducted? Okay, appears to be not for members of the committee. Let's then turn our attention to the May 3, 2018 meeting minutes. These are new and haven't been reviewed before, so there might be additional comments or concerns from members of the committee. All right, hearing none, I'd entertain a motion to approve the minutes.
So moved.
Jackie Gardena, thank you, and Karen Goodman, second. Thank you very much. Any further discussion? Seeing none. All those in favor?
Aye.
Let's vote aye. Or any opposed? Any abstaining? All right, minutes pass unanimously. Thank you very much, and thanks to our staff, our great staff, for the work in putting those together so effectively for the meeting. I am forgoing the chair's report here from this particular meeting. There are any number of items that the group will be considering later in the session here. So I'm actually going to reserve a little time for a chair comment if necessary later on items that are raised during the course of our discussions. But I'll move now to our staff update. And the first item on our staff update is the minimum cumulative bar pass rate compliance update. I think, Natalie, are you handling this one? Is that you? Okay, thank you.
Okay, thank you, Dean Brandis. So most of you know me, but in case you haven't, I've been working with schools for a number of months. My name is Natalie Leonard, and I'm the Program Manager for Educational Standards and also for Legal Specialization. So this really should just be a progress update, but it's a chance for you to ask questions or for the public to comment with questions or comments they may have. For a number of years, the schools have not needed to directly comply with Guideline 12.1, the reporting of the NPR, because some of the information schools needed was not available. So at this point, that information is available again, and earlier this month, we sent to all of the schools the required pass-fail list. I'd like to give a special thank you to Christina Dole, who's here, who created the pass list for all 5 years, going back to make it easier for the schools, and made sure that the list had only the qualified takers. Because this is new for us, that was really quite an undertaking, and I know that the schools greatly appreciate that help from me. So we've received some questions from the schools along the way, not too many. The actual deadline is July 1st. We'll be receiving the scores until July 2nd. And I wonder if anyone has had any question or concern or hopefully good experience with the process to date.
From members of the committee first.
together. We actually started working on them before in conjunction with the matter that John F. Kennedy University College of Law had before the committee associated with the Ranch campus. And our law school staff would work with the forms, and everything worked very, very well. And there's more than enough time to get things filed. So I was very pleased with how it all worked out.
Great, thank you.
Great. Are there any others from other members of the committee? All right. So we do probably have time to take a limited public comment on this one. I think, Bob, if you would move actually to the chair, I think that's what they prefer for the.
Robert Strauss, Dean of Taft Law School. Were the 5-year scores given to the registered schools as well?
These were sent only to the Cal schools because the Cal schools had a regulatory requirement. They were not specifically sent to the unaccredited schools, but you should have received your particular pass rate. And we're lucky to have both Lisa and Christina here with questions about that particular pass rate, pass values.
Well, the registered schools also have a requirement that they have to make a disclosure of the last 5-year numbers for bar passage rate and baby bar passage rates. So if those could be provided to the registered schools, it would be exceedingly helpful.
I can see Christina already sweating. Right? Is it Christina? I'm sorry. Yeah. Already sweating. Thank you, Dean Strauss. Appreciate the comment on that. Practice-wise, we may discuss those matters that are brought up in public comment in connection with an item. And this is an item, so I think we're allowed to discuss a little bit. Justine, is that right?
Yes, that's right.
We are allowed to discuss, okay. All right. As long as they're on an item, we can discuss them. If they're on a non-item, we're not supposed to discuss them.
Right.
I think that's the procedure. So is there any discussion? After all that procedural discussion, is there any discussion?
I would be happy to look into that and to see what would be involved, in particular whether it's possible for us to do the full 5 years for the registered schools or not. I don't think that that's something that we have researched prior to this meeting.
Some of these are automatically developed through the law schools. The general statistics include all of the schools that have taken the bar exam. So I think it's a matter of piecing those together, also including the first year exam.
Thank you for that feedback. We will look into it.
Yeah, I would just comment that obviously, again, as we've said before, the more we can make sure that everybody is reporting in exactly the same definition, right? The less public confusion, the greater the public protection. It's much clearer, doesn't raise questions in the minds of anyone. And that applies to the 6061.7, which does apply to the registered schools. The more accurate that reporting is, even though it's not an NPR, the more valuable, the better we're performing the mission, I think. So I realize it's a lot of work, and that would be the reason for doing it, but to be sure that it continually lined up with the definitions as they should be. So.
And toward that end, it could be to make that segue to the 606.7. We do have a revised form for the Cal accredited schools, and we will need to be creating one for the registered schools as well. So once the MPRs are recorded and verified with the State Bar, it is the State Bar's intention to send out another 6061 form. At this point, it's prepared for the Cal schools, and I'll pass around, or actually I'm going to ask David if he could help me to distribute possibly these 6061 forms. In the interest of the environment, it's a 2-page form, it's double-sided. Thank you. The form looks a little bit different than what you're used to seeing, but the only change, the only substantive change is really at the very end in number 8, directing the school to take the correct information that they've already shared in the 6061, and to update the MPR, and to repost that this summer. And then we'll be giving a report to the committee as to the reposting compliance at the end of August. We think it should be a very simple procedure for the schools. You'll take the 6061 that you already have, simply update number 8, and then repost in the exact same place. And I'm pleased to report that there was 100% compliance in the posting of the 6061s this year. So I assume that this will be similarly perfect. And I thank the schools for their compliance. So we have about 50 copies of this total. I think we should have enough for everyone, including the guests, once they distributed on the table.
And we will be providing the fillable form to the schools?
Yes, we will. I just simply brought the paper version today in case RAC or the public would have comments as to the form. And you're welcome to give comments about number 8, which will be changing, or any other portion of the form.
And I just have a question. I think that in general, what we're seeing is that the school will be able to literally take what's already posted, put that data into this form with the exception of the change to number 8, and repost that form and be in compliance. Is that right?
Yes, so long as the data was correct in the original posting, they will be reposting the same data with only a change in number 8.
Greg,
Yeah.
I have a question. I'm looking at this paragraph that starts with the following data apply. And I don't know if that's new. I don't know if that's new language or not, but and if it is, but I'm reading it as I'm a bit confused by it. The following data apply solely to all first-year students enrolled in the above referenced program who were admitted as of September 15th of the previous year. And so item number 2, tuition and fees. 3, financial aid available. Is that, the way I read that, that information is limited to just people who enrolled and were admitted. So maybe that's true. I don't want this language to limit and not include, because there's other things that deal with first, second, third, like number 4 has got the 4th year, all 4 year schools in it. So I think,
you're saying really probably that paragraph belongs under number 1 because it relates strictly to admission data. Is that right? Or
well, that's, I'm just reading, I'm reading it right now, and that shouldn't be, a lot of the data here is not limited to first year students who were enrolled as of September 15th. It relates also to the second and third and fourth year students.
Mm-hmm. It's funny that you say that because this is actually an expansion of a shorter sentence that was here that only really mentioned the September 15. And we were wanting to make it clear that it applied to 1, and I think you're correct that it may be better to shorten the paragraph and move it under number 1. There was not any change intended, but really just rather to show that number 1 is reported as of students from September 15 of the prior year.
So there's 2 things I think that are going on with this paragraph, right? One of them is setting the record date for all of the data in the form as September 15 of the prior year. So we're establishing that as the date on which we take the census and we compile all the data. And that would apply globally to the majority of the form, right? The second thing the sentence seems to be doing is applying particularly to the admissions data with respect to the students who were admitted as of that date. So that we just have to probably be as clear as we can about the 2 goals. and which they apply to.
I think that's right, and I think that it could just be clarified with drafting, maybe you have the September 15th date as in that first sentence, and then under the admissions date, parenthetically, that this would apply to the first-year students enrolled in the above referenced year, to make it clear what you're referring to. There are two different issues.
There are two different issues. I think it's really critical for the public's understanding that they understand that this is not what they're looking at this form in March of the following year. That isn't necessarily exactly what the school looks like in March of the following year. We're in compliance with the law, reporting what we look like on a particular record date. And the September 15 date is a convenient one because, of course, it ties in the annual reporting and other things. So let's make it as clear as we can for the public in the form that's supposed to serve the public.
And from the school's perspective, there always is difficulty when words enrolled and admitted are in the same sentence, because you admit a lot of people, but they don't enroll. And so, just from a lot of times people think, oh, admitted, well then they're also enrolled. But there's a lot of people who are admitted who never enroll.
Okay, that's good, that's an important distinction.
And then the other issue is, you could be admitted before September 15th, but not enrolling until the spring. So do you mean enrolled as of September 15th or admitted as of September 15th?
I believe I'd like to confer with the statute, but I believe it's enrolled and we can adjust the language to be clear, because we do actually get some questions. We get questions about that first, number 1, A through D, triple I. And I think that could definitely help clarify. We also get a lot of questions about the back portion of this form, in particular about number 7, employment outcomes. That's intended to be a 3 years prior survey. So for this year, would be a survey of your 2014 grads and their outcomes as of 2015, 2016, and 2017. Quite often, I'll initially get data that gives the numbers on the top for the 2014 outcome as they're asked, but then gives the 2015 class employment statistics, the 2016 employment statistics, and then not yet known 2017, and that's when I'll get the call. So I don't know if there are any questions as to number 7, employment outcomes.
And Angela, those calls from the school, those are calls from the school, not calls from the public. Yeah. So there's a need to help explain this to the schools and have the schools understand how to complete it, at least. Well, so would that be solved if we were to say in the box in number 7, the top line where it says employment status, would that be clear the employment status of the class of 2014 or of 2014 graduates as of 2015, 16, and 17? Members of the committee. Would that help? We don't know which schools are having a challenge. We're shooting in the dark a little bit here. All right, well, feedback to staff. I'm to take a look at how we might be able to clarify that language just a little bit for the first section there, the data on the first-year students as well as the employment outcomes.
Okay, and so just to clarify, we're happy to receive these comments, and all of them are intended only to clarify, not to change, of course, the statutory requirement in any way. Okay, the next item is more of an FYI announcement.
And I apologize, could I just make one more thing about this one before we go?
Of course.
If you don't mind. So just reinforcing the conversation earlier about the pass rate data. Again, we've got this language, took the exam down in number 8. We now have the taker definition, right? And we're all on the same page about the taker definition. So now, again, these registered schools are reporting essentially takers in this definition, so that it would be useful to have the data that makes the definitions consistent, so that they could most accurately report based on the language of the statute, which is reflected in the very helpful, if that's possible. All right, sorry.
No, no problem.
On that last, so on 8, B2, it says pass any administration of the CBX, parentheses, or who took the February 2018 CBX and graduated within 10 administrations of the, is that the same February 2018 CBX?
Yes.
I would just insert that to eliminate any potential confusion.
Great. Are there any other comments from the committee about this one? Let me just ask, any other concerns from the public about this one? Dean Strauss.
There were comments in the prior meetings about not releasing information where there were less than 11 takers of a particular exam. And a number of the registered schools are relatively small. Are the schools going to receive information if they only had 5 people take the bar?
So the information that is sent to the schools is exempt from the California Public Records Act. So schools will get numbers no matter what the numbers are.
Great.
Nothing will be posted that would be the smaller numbers.
Okay. Thank you.
All right, great. Now, you're moving to our next item.
Okay, the next one is more of an FYI and a longer term FYI, just to give you notice in advance. Every so often, the State Bar does a required disclosure audit, and we'll be doing that over the course of the summer and fall. We're letting you know because we would rather just let you know up front and have you do the same type of check that we do occasionally. So in the case of the accredited schools, you'd be looking to Guideline 2.3D, indicating the specific statement that needs to be included without alteration in your course catalog or student handbook or on a discrete page readily accessible to the public found on your website entitled Accreditation. We all know what it is. It's just good practice every so often to double check, make sure that you've got it there. From time to time, you might find that you have a webmaster with whom you're not in close communication or who has changed your wireframe and you haven't realized it's moved. So it's just good to do a little housekeeping occasionally. It's really just more of a periodic thing. Nothing else has really spurred that. We just haven't done so in a while. It'll be time to do so again. Just wanted to make you aware, and we'll be sending out a general communication to the schools, letting them know that this will be going on. Does anyone have any questions about that? It's not a new requirement. There's no change to the requirement. It's just checking in with the schools as to your websites primarily.
All right, any other comments from members of the committee on that issue? All right, seeing none, then let's move on to the last item, timeline for implementation of rules and guidelines concerning accreditation lists from the law schools.
Okay, so I'm happy to provide that report, but I also invite Donna and Amy to chime in as they wish. So for those of you who were here during the law school assembly, You're very well aware that the bar for several years has been working on a package of items that had two issues. One was related to a mandatory path to accreditation for registered schools. The other involved a path to Cal accreditation for schools that had a complete online program. So we're looking to tease those two pieces apart. The State Bar believes that the online path to Cal accreditation could be ready to be implemented, while the other portion needs further action from the court and the legislature. So I'm going to focus only on the online if everyone is okay with that. So we're in the process of teasing those things apart. We're working closely with General Counsel as to the approved rules that can go forward. Our intention is to bring a proposal to the CBE at its August meeting for discussion, but this is the point where I could really use your help and your input. We're trying to think about, the rules are already approved, they seem to be very clear, but we're trying to think about the way that the form should look, the types of questions that may come up, etc. And so we encourage discussion here, but we also encourage you to contact the office with questions. So for example, a type of question I might expect is that a current Cal-approved school might say, I see the path to Cal accreditation, my school is already Cal accredited. What is my path now in this new world, under these new rules, if I want to add an online program? So that's an example of the types of questions we might have. If the committee is comfortable with what's put forth at that time, we would imagine a fall implementation of the forms to allow this type of online accreditation. If further study is needed, it could be delayed, but it is our intention to bring a complete package to the committee in August for their consideration. Are there any questions about the timeline or what comes next? We'll ask about FAQs next.
Are there questions or comments from the committee on this? Actually, I'll tell you what, let's take a moment of public comment first from Dean Pritikin, and then we'll bring it back to the committee for conversation. Dean Pritikin.
Thank you, Chairman Brandis. Thank you. So I have a question. I don't know how far this has been worked out, but I know when we were looking at developing those proposed rule changes in conjunction with phasing out the registered unaccredited category, there was a lot of attention paid to the time frame, but with an eye towards, well, we got to give schools enough time that if they have to teach out a non-compliant program that was compliant before, make sure we have sufficient time to do that, sufficient time to make these transitions. Is there thought to, or has there been discussion of what the time frame would be if it was on a purely voluntary basis? How soon you would expect people could apply? Would there be a provisional phase and then full accreditation? What those timeframes would be? I don't want to get ahead of myself, but if there has been discussion about that, I'd obviously love to know sort of where the committee's thinking on that.
Sure. Well, you are correct that the pressure to mandatorily apply will not be applied. And then in terms of a schedule, just generally, it's hard to give you a fixed schedule in advance. We expect that the committee would start to be receiving applications in the fall. It partially depends on how complete the application is at the time and how many further questions are raised as the committee enters a new territory. Remember, this will be the first, California will be the first state to consider a fully online program in this way in an accredited state, and it will be far in excess of the 15 and possibly soon 30 credits that the ABA allows. So I think it would be difficult to give a specific time frame, but I do believe that there is an intention to move forward as quickly as is practicable.
Thank you.
Before we bring it back to the committee, are there other public comment on this issue? I've remembered that our normal process is to take public comment first and then have our committee conversation around it. So are there other comments from the public about this particular matter? All right, seeing none, back to the committee.
Natalie, you mentioned that the committee, you thinking that this might come to the committee in August and then be used thereafter to term something about the fall. What did you mean What's the difference between the August and the fall? What do you envision happening in the fall?
The release of the materials that a school would need to use if they wanted to apply for the Cal accreditation, or if a Cal school wanted to apply for change from a fixed facility to an online or hybrid facility.
Now, if the committee approves it, does it go to the board? And, yeah, okay. That's the reason why I was asking about the fall is I would think that there had to be a step following committee action, which would be board approval.
So we're thinking to be able to take it to the board in September. There are some grammatical changes and other non-substantive changes to the rules that we think would not require any comment or anything like that. But we need to bring the concept to the board that we're separating, we're teasing out these two pieces. As a matter of fact, I had a preliminary conversation earlier today with the chair of the programs committee, letting them know of this very same timeline and that this is what's happening. So the board so that it won't be news to the board at the subcommittee.
And procedurally, does the court get involved?
I would say not with this set of rules because there's no change to any of the court rules.
Because in the mid-2000s, when the committee was considering the accreditation of online schools, the court had definite opinions about whether or not accreditation of online schools was appropriate. That led to the task force on the online law school task force. And so I just didn't know if the court had acquiesced or what the involvement of the court was in this matter.
My understanding is we're okay to move forward with the online schools.
Yeah, we will continue to have informal conversations with the court and make sure that there aren't any barriers there. But as Desi indicated, that we're not making any changes to the rule of court. This is strictly to the bar rules and actually just the guidelines, minor change to the rule. So we don't anticipate the need to get formal.
And some of those prior discussions that involved the court involved a mandatory path, so I would think that the court would be much more actively involved in something.
The ones I was referencing was the online task force, which was 2003, 2004, thereabouts, where the court, there was court involved.
And Dean, I'll just comment that I think, my understanding is the court has recognized that this is, the legislature has delegated authority to the Committee of Bar Examiners to both accredit schools and to regulate unaccredited schools by the Dunn Bill in 2006, which became effective January 1st, 2008. And that's what brought the registered law school rules into being. And so I think that there's probably some recognition by the court that the legislature has taken this on itself in terms of the accreditation function, not the admissions function, but the accreditation function. It's probably a legislative power as opposed to the court. I don't know if the court's really done that, but it's a pretty good argument for what they could have said if they decided they were not going to be involved in this particular.
We certainly would never deign to speak for the court.
Right.
And then returning to the second part of what I was asking, the other thing we would entertain would be any live questions that you may have so far about the process. I know this is really more of an introductory thought. You may not have questions now, but I encourage you to forward them to me at the State Bar. This would be a very active time to do that. We'll be working on the materials actively for the tiny remainder of June and the first part of July. So if you have a question on your mind, don't worry that it's already been asked. We'd like to hear it so that it can be included in the introductory materials that we send out.
Okay, are there other comments from the committee? This is not a voting item or anything, just feedback from the staff report. Okay.
Just a quick question, having not been here through the entire process, the CBE anyway has been involved in the changes to the guidelines all along. And so I'm assuming we're not anticipating any issues, especially since this is a voluntary access to accreditation at the CBE level. Is the board similarly, are you anticipating any obstacles at the CBE or board level?
Well, I wouldn't, again, just as I wouldn't speak for the court, I wouldn't speak for those bodies, but the intention is to move forward with the body of rules that has already been approved in principle by the CBE, as well as the Board of Trustees, without changing that corpus.
So there's no necessarily approval on their part that needs to happen, it's just for discussion purposes only?
We're in a slightly novel posture in the sense that we're teasing apart two elements, so I wouldn't want to say for sure that questions wouldn't come up related to that teasing apart, but I do believe we'll be presenting to them settled rules that they've considered before.
Thank you.
Okay, is there anything else on this particular one? All right, let's move on then to our item number 5. This is addressing one of the goals that the RAC set for itself during this year, respecting the questions concerning information that schools provide in connection with compliance to the State Bar in the new environment of the Public Records Act and the other specific acts governing the disclosure of information provided to the State Bar. And we're fortunate today to have Desi Overbeck, counsel to the Committee of Bar Examiners and part of the Office of General Counsel, to present to us on some of the existing rules, and then I think get some feedback from us about what we think about that after we have still have concerns.
Thank you, Greg.
Thank you, Desi.
Yes, I'm Desi Overbeck. And the purpose of my presentation is to help explain what a trade secret is, because discussion of trade secrets are exempt from disclosure, or the documents that could be trade secret documents are exempt from disclosure under the California Public Records Act, and discussion about those trade secrets are grounds for a closed meeting under Bagley-Keene Act. So because of that, there has been a request to get a better understanding for what is a trade secret. So first, let me remind you that this is for informational purposes only. I'm not representing any of the law schools here. I'm not giving advice. Okay. Again, although we're going to be talking about maintaining confidentiality of trade secrets, keeping in mind that trade secrets could be part of the documents that are provided to the State Bar in response for an accreditation, or they could be topics that could be discussed in a CBE meeting. Let's first review the policy behind Bagley-Keene and the California Public Records Act. The idea behind those acts is based on the concept of sunshine in government. We're dealing with competing interests. One is the public right to access information and ability to monitor and participate in the decision-making process. And the other is individual privacy rights, and in this instance, the protection of trade secrets. So, as you know, we're subject to the Bagley-Keene Act. As of this year, starting in January, the Committee of Bar Examiners was subject to the Bagley-Keene Act. And also, as of January, Business and Professions Code 6026.7 provided an exception to the Open Meeting Act requirement in Bagley-Keene, which is C5, and it states that a closed session may be held for meetings relating to information about a law school's operations, that constitutes a trade secret as defined in subdivision D of section 3426.1 of the Civil Code. The purpose of this exclusion or exception is to allow a law school to protect its trade secrets, because by definition, if a trade secret is public, it is not a trade secret. Also a reminder, the State Bar is subject to the California Public Records Act. We've been subject to this a little bit longer, since 2016. And the Public Records Act creates a presumptive right of access to any record created, or in this case, maintained by the State Bar that relates in any way to the State Bar business. The State Bar is required to disclose any requested public record unless there's a statutory exception. The exceptions must be narrowly construed, they are discretionary, and the State Bar would have the burden of demonstrating if an exemption applies. Again, I know that you've heard a lot about the CPRA. I'm not going to spend much time on it other than a quick overview of where the exemptions come from. They are listed in the Act, and certain other exemptions are incorporated into the California Public Records Act. Also, where the public interest in not disclosing a record clearly outweighs the public interest served by disclosure of the record is a test that is a balancing test. Generally, the exemptions are listed in the Government Code, section 6254. And then 6254K incorporates exemptions that are not specifically listed. One of the examples came up previously when we were talking about FERPA, the federal law for students' privacy rights. If you give us information about students individually, that's something that would protect us. That would be an exemption for not disclosing a record that would contain that kind of information. Now when we're talking about trade secrets, it is Evidence Code section 1060, which provides a privilege to holders of a trade secret, and that is incorporated into the California Public Records Act. So that would be the basis for not disclosing a trade secret if it fell within a Public Records Act. Okay, getting to the meat of this. What is a trade secret? This is the definition in the Civil Code, which is incorporated into the Bagley-Keene closed exemption. California has adopted a version of the Uniform Trade Secrets Act that was enacted in 1984, and this is a codification of that. So first, a trade secret means information, including a formula, pattern, compilation, program, device, method, technique, or process. Going back to the word information, most commonly we see that it's technical information or business information. All right, so that is then modified by it must derive independent economic value, actual or potential, from not being generally known to the public or to other persons who can obtain economic value from its disclosure or use. So the comments in the Uniform Trade Secrets Act state, if the principal person who can obtain economic benefit from the information is aware of it, then there is no trade secret. Again, that goes to the idea that somebody else doesn't know the information. If they already know the information, there is nothing to be protected. When we talk about value there in that first subpart, value comes from the fact that other people don't know it and therefore cannot use it. Also, if a potential competitor would have to spend time or money to develop this concept, that's another way of looking at the value. Okay, and then finally the last prong here is that it is a subject The trade secret must be the subject of efforts that are reasonable under the circumstances to maintain its secrecy. So here, for example, if a law school had a trade secret, they need to be able to show that they have limited access to that information on a need-to-know basis, that they require employees to sign a confidentiality agreement, that there's been some effort made to keep this information secret. I'm going to give you some examples of technical and business information that might be considered a trade secret. Technical information doesn't pertain a lot to law schools, but I think it will help explain what we're talking about. So for example, plans, designs, and patterns, such as those for specialized equipment, would be considered a trade secret. Processes and formulas, for example, food or drugs or chemicals, the formula for Coca-Cola, that is a trade secret. Methods and techniques for manufacturing, engineering notebooks, also negative information, for example, designs that did not work, and computer software like programs and source codes. So for business information, and this starts getting a little more meaningful, that would include financial information prior to public release. Obviously, once it's released, it's no longer a trade secret. Cost or pricing information, manufacturing information, internal marketing analysis or forecasts, customer lists, unannounced business relationships that one is negotiating or is about to enter into, information about a business opportunity, such as an opportunity to acquire another company, marketing or advertising plans, and personnel information, such as who are the key employees, what's the compensation for a key employee, who would be a good target to hire away because they have special knowledge. Okay, so this slide are two different quotes that come out of the Alta Beyond case. Oh, sorry, just not hearing me. And the top definition, as you'll see, is very similar to the statutory definition we have. Your trade secret is something that needs to be used in the business, and it gives him an opportunity to obtain an advantage over competitors who do not know how to use it. Again, secrecy is an essential characteristic of information that is protectable as a trade secret. Whether information constitutes a trade secret is a question of fact. It's not black and white. It's not always going to be the same from case to case. Although courts require a business to label something as a trade secret, labeling it as a trade secret or as confidential information doesn't just make it so. You can't just stamp on confidentiality and there you go, you have a protected trade secret. In the area of law school businesses, areas that I've thought of that are of potential concern could be online educational programs, business information, products, or marketing or advertising plans. On economic advantage, you do have to show that the information is valuable. However, the economic advantage doesn't need to be great, but it needs to be more than trivial. So, again, the courts aren't giving us huge answers to this, but you do have to have some kind of economic advantage. And secrecy. So secrecy is an essential characteristic of the information. You have to use reasonable efforts to maintain that secrecy. And trade secret information that is contained in documents that you're producing, for example, to us because you're required to, it needs to be labeled. Also, trade secret status can be lost over time. This makes sense. For example, new technology, when it comes out, nobody knows anything about it. Over time, it becomes public knowledge. It's lost that trade secret status. Secret business information, such as bids or prices, once they're released, they're no longer secret. And of course, any information that has to be posted on the internet is no longer secret, and that, at that point, would lose any of its protection. This case, agencysolutions.com, discussed these 4 different lists of things that are not trade secrets. General knowledge in a trade or special knowledge of persons who are skilled in a trade does not constitute a trade secret. Ideas or concepts in and of themselves are not trade secrets. Proprietary ways of doing the same things that other people do in the same fields are not trade secrets. But there may be a way of some discrete fact in the way you do it versus the way somebody else that could be considered one. And then the 4th is talking about programs. If you can see how the program is working because of the flows and inputs and outputs, that is not a trade secret because it's evident in the operation of the software. But source code it could be considered a trade secret. So my next slide, I looked at the list of required documents that are given to us with an application for registration. And I think these were the first 8. The written refund policy, required disclosure statement, the student disclosure statement, the written policy for imposition of student discipline, written academic standards, written policies on examinations and grading, the written statement students get regarding grading, and student services and activities. All of these documents are information that are given to someone else. They're given to the students. They're required to be posted publicly. So none of them fall under this trade secret area. And the reason I'm calling this out is I think if we have any trade secrets, they're going to be very limited. So to wrap up, whether something is a trade secret or not is going to be a question of fact. It depends on various factors. Is it publicly known? Does it have an economic value because others don't know it? Have there been efforts to keep it secret? And information that has been publicly disclosed is not a trade secret. So for example, wherever we have a statute that requires public disclosure, that is not a trade secret. The legislature has, made a requirement that this needs to be considered public information. My recommendations are, if you don't need to produce a trade secret, please do not give it to us. Because once it's in our hands, we are subject to making a determination if there's a request for something to be disclosed or if there's going to be discussion. Does it really fall within this exemption? And then secondly, if it does have to be disclosed, you need to identify it in the documents as you're producing it. Just because you've identified it doesn't mean we're going to agree with you, but at least tell us to start with, because if you don't, we're not going to expect it to be considered a trade secret. And keep in mind that the ultimate decision will have to be made by the State Bar. So that's my overview, but I am happy to discuss this or answer any questions to the extent that I can.
So before I turn it over to first take some public comment and then conversation, the most important thing first is to thank you for the evident hard work and extensive work involved in compiling this overview of the area. I thought it was terrific and led us right through the process from one step to another and how it falls under the Act. I think, probably speak for a lot of us saying, we probably thought that some of this did fall under the exemptions, but we probably didn't really understand what it was or the nature of how it fell under the exemptions. And so thank you so much for taking the time to pull together the examples and cases.
Thank you, Greg.
Yep. So thank you so much. All right, so let's take a little bit of public comment, if there are any. Dean Winnick?
Couple
couple of hypotheticals. Now, two things came to my mind, which don't quite fit into this category, so it's just a question and you may not know the answer right now. So, for example, the rules require, there are times that the rules require us to show that we are, that a proposal is financially sustainable. So the easiest way to do that would be to show multiple years of financial projections. So for the typical company, that's about as private. It may not be a trade secret, that's about as private as we think we get. So it's required by the rule. That would be the most common way to do it. And yet that would be the kind of information that I know many boards would be very happy to give to the accreditor, but wouldn't want to see it as part of the public document. So I guess I would just throw that out as a question of a category that might commonly come up on a repeated basis in a variety of things. So that's number one.
Well, I was just going to say, besides possibly being a trade secret, it also it falls into that area, the balancing test of is it more important for the public to know versus the privacy right of the entity that is giving this information?
Yeah, because I would put it in the category, I think it's important for the accreditor to know. It's just not something that I think would be important for the public to know. So that's almost a second category. The only other one that came to mind would be, so one of the questions in I think it's the 5-year review, it may be in the annual report, I don't recall. It talks about improvements in bar pass rates, for example. And there may be some of us, that really, the category that said, it was back a couple slides, along the lines of the way you do a process that everybody does. That's not exactly what the wording was. So obviously, that's it. Ways of doing the same thing that others in the same field do. So obviously, all of us do that in some way. But some schools, I would suspect, believe they have a secret sauce of combination of contracts with providers, special courses, tutoring, and bar pass rate, I mean, is a competitive factor, I would say, and if we step aside and look at competition among schools. So I'm wondering if that one just strikes me as one that might be interesting, because we've historically answered in great detail what we're doing, because we're proud of it, and we want to really tell the accreditor, look, we're doing all of these things, but that's a lot of work, and that, I think most of us would think is proprietary at some point. Again, and I'm not sure it's a trade secret, but it is something that I wouldn't necessarily want to just hand over, because some of that's the result of 3, 4, 5 years of trial and error of internal programming. That wouldn't be in our curriculum guide, it wouldn't be in a public disclosure, it would be more in the policies and procedures of how we work one-on-one with students. So just another thing to make it more complex.
No, it's good to hear, what the concerns might be. That is definitely helpful.
Okay, yes, another public comment.
You indicated that public secrets needed to be labeled as public secrets. You also indicated that the school's financials, in your opinion, were probably in the trade secret category. In the annual report, since we have to disclose financials, should those automatically be labeled as trade secrets?
I would mark them confidential / trade secrets, yes.
Okay, and then any other documents, for instance, in the 5-year review, I know we have to put in examples of courses, we need to put in final exams for certain courses. Those are obviously material that could be considered trade secrets. They are copyrighted materials for most schools. do we, I guess, have to put trade secret on the final exams that we give our students in order to protect them? I mean, they are labeled as copyrighted.
Can I ask you a question
Sure.
about that? So the exam questions that you're giving us, you would continue to use after you give them to us?
Potentially, yes. Particularly if they're the multiple choice questions and they're part of a data bank of.
So there's another exemption in the California Public Records Act that is exactly for test questions, which would probably be the more, the right-on point thing. But again, yeah, I mean, as I read the case law, you really want to make sure you're labeling it that it's either confidential or trade secret, because if someone challenged you, the court's going to say, well, you turned it in and you didn't indicate that you thought it was. So I think you want to do that as a, both as a protection, but also to alert us, so when we see the document, we think twice. Okay?
Thank you.
So any other, there's going to be one more. We'll give Dean Cragen the last word.
Sorry, I'll be brief. So I don't know with our past submissions if we've marked our financials or whatnot as confidential / trade secrets. If we haven't, should we send in a supplemental addendum saying, please consider this trade secret, etc. at this point?
So we're entering into the legal advice area.
Just information, just looking for information, not advice.
Hypothetically speaking.
Hypothetically.
Personally, I don't think you need to do that. The rule was not, that was not the law when you gave it to us. At that time, everything was considered protected. So I think you're probably okay.
Thank you.
Okay, we'll close public comment on this issue at that time. Now back to the committee members. Dean Barbieri.
First of all, Desi, this was wonderful. Thank you very much. Very informative. But as you were going through it, like Mitch, I share a number of the concerns, and I understand that whether something is or is not a trade secret is a question of fact. And I'll give you a hypothetical, which was actually a real example. As we all know, that I recently, on behalf of JFK, filed a petition for a major change to open a branch campus. Prior to doing that, we did extensive market research and paid a lot of money for it. And I didn't include all of the information in my petition, because if I did, then everyone would have received the benefit. And during the whole process, people criticized me for saying, oh, well, he didn't really disclose much when we already had done something. So if I then put it in the report and labeled it, this is a trade secret, but someone at the state bar says, oh no, this is a question of fact and we're deeming this not to be a trade secret, then I've lost it again. So procedurally, I'm still not at I'd love to have, it's like having a meeting with the judge and saying, confidential, is this, will you take a look at it? Will you make a determination that this is a trade secret or not? And because, again, I agree with Dean Winnick. I think it would have been very beneficial for the committee to see it, but I wasn't willing to dump it all for the public to see because it was something of value. And so I'm not looking for advice or whatever, but I think it would be helpful if we developed at the committee level and state bar level a process whereby one could try to get a determination if something is a trade secret before they include it in a document. Because once it's included in a document and it's determined by someone before an appeal that it's not a trade secret, then you've lost the benefit of this work product.
I wonder if staff has any comment on that. This would be some kind of either internal OGC sort of process or it'd be a guideline or be something good to implement
Well,
that.
can I throw something out? So as far as the discussing something in closed, I think that it would make sense for, let's say in your hypothetical, for you to, for there to be a way to find out before the meeting, is this something that we can put on the closed agenda? Which, you know, is why we have this exemption. And it could be discussed with, you know, even if you had to hand out things, then you could take them back. And that would give you the, protect your concern before you've given something
Yeah,
away.
that's all I was asking
Right.
for.
So I do think that we could probably come up with some kind of a system.
Yes, and I think that we've talked about reviewing the major change request portion of the guidelines, and maybe this is an item that we need to incorporate in that process too.
So, but not to complicate matters, in filings, apart from major change filings, let's say, if you had something, another aspect of this would be if you had something you thought that you believed was a trade secret, would there be a procedure for getting a determination from the bar on a confidential basis that was non-disclosable, clearly not disclosable in that conversation, before filing it as a part of a report? So whatever that might be, it might be these marketing plans. Let's say, can you send it to OGC and say, how would you treat this? Would this qualify in your view under the exemption or not? And therefore, basically, the bar would be saying, we'll treat it that way, or we'll undertake that obligation. Because as you say, it's really the bar's determination how they're going to treat the information. And schools, I think, would be reluctant to provide that information to the bar unless they could get a predetermination, you know, some kind of read on it ahead of time. So definitely open meeting is part of that. I agree. I'm with you completely on that. Then the question would be, as respects other things, might have to be filed. You know, discussion in a meeting.
So I have a couple questions, I have no answers. I think these comments are good, and I think Destiny's presentation is good. I think where you see the issues really come about are these requests, major change requests, and the 5-year inspection. And I'm just thinking hypothetically, if we get a lot of information on a 5-year inspection, let's say it turns into that, for whatever reason, we don't pass the school, then there's litigation. What do you do that? Because then how are you going to claw that back unless you have the domain that these are protected trade secrets that potentially could be available then to competitors? So that's, I think, I mean, so what I was waiting for and was thinking through, and Mitch really helped me out think through this, where are the specific examples of communications between the bar and the schools where trade secrets are most likely to come up. And I think those are the two major issues. And I think it would, for lack of a better word, think of some process such as what we do in my world, filing under seal, being able to file under seal and getting an advisory opinion. I don't think those should be public record, but by the same token, Dee makes a great point. There were questions because of the nature of what you were seeking to do, hypothetically, that you had, that because of it going out and being filed and being attached and made a matter of public record, you could safely disseminate to the committee that would have informed us. So there's got to be some way to deal with that. And knowing that it is a clear exception to vaguely keen, I think it's incumbent upon us to give guidance to the staff, so hopefully me, give guidance to the schools as to how best they need to identify trade secrets that fit within this, because they have, and where I think it comes up, admissions policy, retention policy, and what the individual schools are doing to increase bar passage rate, that I think all very proprietary, and not something they necessarily want their competitors to know what they're doing. So those are at least my thoughts.
So I'm going to ask if that's a motion to recommend that staff take a look at a I think it would probably be a committee of bar examiners policy, right? It wouldn't be a guideline, now that I'm thinking about this. It'd be kind of like the definition of taker and completer policy. It's a way that it would be a way that the committee conducts itself or something. To provide for that file under seal and sort of in-camera review by some appropriate party with a written determination about whether the bar would take the stance to protect it under one of the exemptions that's required. Oh, so it's not an action.
So I'll have to go back.
It's a, what is it? It's a, okay. All right. Yeah.
Good catch, Natalie.
Right. So discussion today, so we're not moving quite so far, so.
But I would like to see staff come back, perhaps, and put this on as an agenda item for our next, whenever the next RAC meeting is. I think that would be helpful.
Okay, so is there other discussion on it? Since I now jumped the gun. And Ray, you've been brought back to earth. Okay. Again, Testy, thank you for the marvelous work. It's really, really helpful to have this understanding as we kind of explore how to interact most effectively and appropriately. All right. That takes us then to the possible revision of Guideline 4.7C1 regarding yearly evaluation of new faculty members. Ms. Leonard.
Okay, thank you, Dean Dennis. So I asked David to place up on the screen, you can see it here, Guideline 4.7C Step 1. So we need to push down just a little bit more. So this has to do with the evaluation of faculty. So this is, there is not a specific guideline proposal put forth before you today. This is really more a very preliminary introductory information gathering session, and I'm looking to gather information from the members of the RAC, or also any members of the public who may be present. Right now, as the guideline currently stands related to faculty evaluation, new faculty must have at least a verbal evaluation in their first year, and then after that, faculty must have written evaluation placed in their file every 3 years. At the last committee meeting, the committee was thinking about performance reviews, which you think about in business environments, that generally the employees are evaluated once a year, and those evaluations are placed in their file each year. They wondered why the guideline was not every year for every faculty member, and this guideline doesn't preclude that. So we were just wondering, is actually every year faculty evaluation typical, or are there barriers that the committee might not expect to doing faculty evaluations that are written every year?
All right, so following our script, we've taken our staff presentation. Let's take a little bit of public comment if there is any.
That's a great question. I was in, and just for your
Dean Winnick.
Oh, yes, Dean Winnick, Monterey College Law. We struggled with this. We completely overhauled ours a couple of years ago because we weren't. I think when we first changed these rules, it was fairly recently that we added the 1 year, 3 year part, if I remember. And so we looked at how to do that. One of the challenges in a night program, which is virtually all the CALs are, with adjunct faculty, is to have an in-room review of one faculty member from another faculty member isn't as easy as you would think. Because now you've got to get somebody else who's used to coming in once a week to teach, you got to get them to come back in. And I know it sounds a little like whining, and I'm really not doing that. Well, yes, maybe I am doing that. But organizing adjunct faculty for extracurricular, extra activities is a challenge. And particularly if you think about a program like ours, we have 40 faculty. I mean, you forget that, we've got first through fourth year, and so it's a lot of them. So I think this proposal came out of, if I remember correctly, and others, and Dean, you were probably around, we talked about that, it's kind of a middle ground. We wanted to make sure that everybody got evaluated on a regular basis, and I think we decided that was every 3 years, but we particularly wanted first-time faculty to get evaluated right away. So I think that was how the 1 year, 3 year came about, and why we didn't just leap to everybody every year, if that helps.
Thank you, that's very helpful. So as a practical matter, do you schedule on an every 3-year basis or varies a bit?
We have another public comment. Dean Strauss.
Robert Strauss, Taft Law School. Part of the standard also came from the Distance Education Accrediting Commission standard, which is a first-year evaluation for new faculty and 3-year evaluation for experienced faculty. The other comment that I would make is that faculty that teach on a periodic basis, particularly specialized electives such as intellectual law or healthcare law, they may only teach every 2 years, 3 years. They're not necessarily people who are going to be around on an every year basis. So this schedule, I think, is a good one. It complies with the standards in the field of accreditation, and it's very practical for many of the faculty that do teach on less than an annual basis. Thank you.
Any other public comment? All right, let's bring it back to the committee discussion. Dean Gradient.
Jackie Gardina, Ventura College and Santa Barbara Colleges of Law. So I think this is a great topic for us to cover. I think following up on what Dean Wittig said, it has been a challenge when you're relying on full-time practitioners and judges to ask them to come in a second night or a third night to evaluate what would amount to essentially 12 to 24 faculty members over the course of one semester. I think the other thing that I have found challenging is because they're full-time attorneys and judges, they don't necessarily have time to think deeply about pedagogy or what is good teaching or how can someone do it well. They mimic perhaps what they had in law school, or perhaps just they're innately good teachers, as some people are. So you tend to rely on those people you know are really strong in the classroom and have a good pedagogical approach so that they can accurately kind of assess how someone is doing. And that even narrows the number of people down even further. So I think it's an important topic for us to discuss, but those are some of the challenges that I've run up against as we implement a teaching evaluation system at the colleges of law.
Other members of the committee?
Dean Barbieri, John F. Kennedy University. I concur with the other comments, and I think another factor, at least when my recollection is when we discussed this, is a number of our schools have had professors who were practicing lawyers and judges that have been teachers at the colleges or the law schools for 5, 10, 15, 20. We have someone who's been in school for over 30 years. And because of the limited resources and the time associated with it, is having Judge so-and-so get evaluated every year when Judge so-and-so has been teaching for 20 years and always gets outstanding student evaluations and everything else. It's that every year could be considered a bit of an overkill, and every 3 years certainly Because in intermediate, you get evaluations back from the students, and if there's an issue, then you should be able to go back into the class and to do some evaluation or corrective action. But every year for someone who is a proven excellent teacher, I think is too much to expect of our schools.
And I would just comment that inherent in all the comments that you've heard is this notion of peer evaluation, that's what distinguishes this from the typical employment evaluation situation. The norm in academia is that you are evaluated by your peers, or a panel of your peers, or someone who similarly has expertise in even your subject matter area. And that's very different typically from the kind of employment evaluation that you see being done on an annual basis. Were you nice to people? All those things that go into those employment evaluations. It's actually a different process than what you expect. It also takes an enormous amount of time to do well, to give developmental feedback to particularly an expert peer who's very good in the classroom. It's a lot of work for typically an adjunct that you're assigning to go evaluate another adjunct. So in practicalities, there's a number of these practical things, and all that adds cost because adjuncts and folks they're not on regular payroll, and everything we have to do more often means we have that expense more often. So in a model where we're trying to maintain the affordability and accessibility of these schools, obviously amping up something like this is actually a real cost. Okay. Other comments from members of the committee on this one? Did you get what you need?
Absolutely. This was really just a data gathering moment, and I appreciate everyone's active participation. This was very helpful. Thank you.
Right. Well, that takes us to the last item on our agenda, which is the goals check-in. As always in these meetings, we take a moment to glance back at our goals and note progress. I would note that particular thanks again to Ms. Overpeck. We have checked another item off the goals. We're not quite off the goals, but we've made progress on yet another item on our goals in this meeting, and that's our goal, of course, of addressing the question of trade secrets. And so thank you so much for helping us move that along. We still have a couple of things that we have to continue to work toward. That's goal number 4, substantial compliance. Goal number 1, minimum competence. We'll continue to work on these. And I think that we've addressed most of the others. Are there variations or modifications or additional goals that any of the committee members want to propose for the RAC at this time? Okay, hearing none. That's our check-in on that, and that brings us to the end, unless there are other things from the staff or members of the committee. Recall that we can only talk about things we noticed. So other items on the agenda today about which there are questions or comments from the members of the committee? Okay, or I should say from the staff. Okay. Well, then I'd entertain a motion to adjourn. So moved by Dean Barbieri, seconded by Mr. Lynn, and all those in favor. Thank you. Thanks everybody for being with us, and to members of the public for watching us do our work today.
Oh, yeah, it's a mic.